For those of you that don't know me, I am the Symposium editor of the Law Review. I'm here to give a few closing remarks as we reach the end of today's event. First, some concluding words on CLE. I have a required note from the CLE office. If you are seeking CLE credit for today's event, please remember to fill out your digital evaluation form and include the CLE passwords announced throughout this event. The evaluation form is mandatory to receive CLE credits. Please find the link to the evaluation form in the Zoom chat or on the QR codes that we've dispersed around the auditorium today. Second, I have a few closing words on the event itself. This event is the Law Review's 32nd symposium, by my account. It is the first, however, to deal with legal questions surrounding the foreign affairs powers. And I think that the end to this wait could not have happened at a better time. Today's world combines familiar challenges like great power competition, terrorism, with evolving threats coming from disease, technology, and still more dangers that we have yet to find out and will probably read in the newspapers in the coming months and years. And how we interpret and view the law affects how and by whom these challenges are addressed. And today's conversations not only promise to contribute to doctrinal debates, but also have immense practical relevance in answering these questions. I'm likewise proud to share that the discussions today will produce 8 papers in our print publication and 1 article in our online publication later this spring. So keep your eyes out, please read them. We've been fortunate to hear from a truly all-star lineup of participants who, in addition to being experts in their field, bring experience from across all 3 branches of government and no less than 12 distinct government agencies and offices. And this is almost conclusively a conservative estimate. Thank you to all of today's participants for coming, both near and far, to participate in today's event and to make it one to remember. Additionally, this is not a one-person show. There have been a lot of people involved in helping make this happen, and I want to make sure that they get the recognition that they deserve. First, thank you to Ralph Mullen, the Law Review's administrative coordinator, whose tireless assistance has not only helped bring you today's event, but helps keep the Law Review running every day. Clay, Michael, the Articles Office, thank you for your steadfast support of the symposium topic, from proposal to putting on this event. It has meant a lot to me. Thank you to all of my Volume 172 colleagues for their help today, especially Bryce, Rachel, Ray, I don't see you, but thank you for being my eyes and ears today while I've been running around. Thank you to the facilities, student affairs, communications, IT, and CLE staff, particularly Dimitri, Lisa, Julia, Sam, and Chris, who's been in the booth and helping make all of this work. Axel, my predecessor, he's not here today, but he's viewing online, and I wanted to thank him for trusting me to carry on this role and being a source of guidance and support while figuring out how to be a symposium editor. Also, a special thank you to our firm sponsors, Arnold & Porter and Morrison & Forrester, for their generous support of this event. Last, but certainly not least, thank you to our faculty co-organizers, Professor Curtis Bradley, Professor Jack Goldsmith. One thing I've mentioned to a number of people is this isn't an event that we typically have at Penn. You can find all the corporate events that you want, not so much in terms of international facing issues. And I really appreciate you putting the trust in us for putting on this event. And my hope is that it can not only bring about some important conversations, but spur some interest in these types of discussions and areas of law here at Penn. And with that, I will turn things over to Professor Jack Goldsmith for the very last words of the evening.
Very last and hopefully brief words. Thanks again to the students. We thanked you a lot. It's been an amazing conference. We're very grateful. Thanks to the great paper writers. As drafts for conferences goes, these are extraordinary papers. Thanks to the panel discussions, to the commentators, to the moderators who did a great job. Thanks especially to our special guests from the real world who were on the keynote lunch panel and who took a whole day off from their real jobs, unlike the academics here. And it was an amazing discussion. We're very grateful for that. So just a few final thoughts. The statutory foreign affairs presidency is not a new thing. It's a very old thing. One of the things that the originalism debate about the non-delegation doctrine has revealed is that there were masses of delegations and authorizations to the president in the early years. In fact, it was the dominant context. And if you think about the classic cases, Little versus Bream and Brown versus United States, presidential power has always been connected with statutory authority. In fact, in the courts, there are only a handful of Supreme Court decisions that actually touch on in a holding independent Article II power. The vast majority of foreign relations cases involve statutes and treaties connected with executive power. So we've had the statutory presidency, foreign affairs presidency, from the beginning. It's an old issue, and yet there are so many uncertainties today about delegation, about the proper interpretation of these authorizations. We still have massive uncertainties about the scope of Article I or the commerce power, Article II, or about the commerce power in Article I and how they should fit together. There are continual, incessant debates about particular exercises of presidential power pursuant to statutes. And I have to say, one thing that I learned today is the amazing persistence of foreign affairs exceptionalism. None of us could get away from it. Kurt and I tried to write a paper without it, and we did mostly, but we still had to confront it and deal with it. And that's something that's important and we should probably think about. So why so much uncertainty? Why about the nature of these things? One reason, as Chief Justice Rehnquist said in his opinion in Dames and Moore, is that Supreme Court decisions in this area are rare, episodic, and have little precedential value because they tend to decide things narrowly and in discrete contexts. Another reason, Congress doesn't legislate very much in these areas and doesn't do so precisely when it does. I have to mention an exception to the rule, and that is the National Defense Authorization Act, which for 1,000 to 1,500 pages every year puts down very, very precise rules for the most part connected to mostly the military, also the intelligence world, and everything else, because everyone wants to get into this statute. That's another conference why that happens there. But for the most part, Congress doesn't legislate in these areas and doesn't legislate specifically. The president has massive responsibilities. The world is changing. It's a dangerous place. The president always has to deal with new problems and is responsible for dealing with them, so the president acts. And that means that it ends up being a debate between the president and the courts. And the courts, to the extent that these issues come to court, and the courts, as we know, the new conservative Supreme Court is really going through what can only be described as a radical rethinking of interpretive doctrines across the whole array of presidential authorizations. And one of the questions today was, how much is that going to impact foreign relations? So I think it's fair to say that these issues in foreign relations law and the statutory presidency are maybe at an inflection point. And I hope these papers, once published, and I'm confident that they'll be elucidating and helpful in sorting out these issues. So we look forward to the editing process, and we thank you all for coming, and thanks very much for everything.